Chapter 3 is Courts and Alternative Dispute Resolution. The first concept is judicial review. This Marbury versus Madison case was decided by the U.S. Supreme Court, and it said that the courts have the ability to review what the other branches of government are doing to determine whether they're constitutional or not. Jurisdiction means juris, law, diction, to speak, or the power to speak the law. If there's an actual controversy between parties that's before the court, a court has jurisdiction to speak the law and render a verdict that's binding on all the parties. And personam jurisdiction means jurisdiction over the person. It's the power of the court to compel the presence of parties, including corporations, to a dispute to appear before the court and litigate. In rem means property, so in rem jurisdiction means jurisdiction over the property. It's the power to decide issues relating to property even if the person isn't within the jurisdiction, and that property could be real, personable, intangible, or intangible. A long-arm statute is a state law that gives a state court jurisdiction over somebody who is not a resident of this state as long as they've had minimum contact within that state. So for example, if a business that is headquartered out of state advertises, sells good within a state, then that court would have jurisdiction under long-arm statutes. In terms of sufficient minimum contacts of a corporation, usually jurisdiction in the state, it's corporated has jurisdiction where they have their principal place of business, where their goods are sold, or where it actively advertises. And there's an example of that in case 3.1. A court also has to have jurisdiction over the subject matter. Courts are limited to what kind of cases they can hear. There's cases of limited and general jurisdiction, but you go to a specific court to have bankruptcy cases decided. For example, bankruptcy cases are decided in the federal district court because that court has statutory subject matter jurisdiction. Another way of looking at jurisdiction is original and appellate. Another word for original jurisdiction is trial court jurisdiction. It's the court that you are supposed to originally go to where you have your trial. Appellate courts, they just hear appeals. So instead of hearing evidence, hearing from witnesses, they just review the record of the lower court and consider whether the decision was proper. Usually they're looking at just the record from the lower court. Jurisdiction in federal cases, there's two ways you get to federal court. One is if it involves a federal question. That might be under the U.S. Constitution, some federal action or federal law. The second way is diversity jurisdiction, and you have to have both these things. You have to have a party who's from a different state, so the parties are diverse, and then the amount in controversy is greater than $75,000. Venue is a separate concept from jurisdiction. Jurisdiction has to do with power, venue has to do with location. So several courts might have jurisdiction over a case. Venue has to do with the most appropriate place for the trial to happen. As it says, generally the proper venue is where the injury actually occurred. Let's look at the state court system. In every state court system, there's a trial court, appellate or reviewing court, and highest court. They often have different names. In Michigan, we have the district court, the circuit court, the Court of Appeals, and the Michigan Supreme Court, but that might differ in other states in terms of the names. But there's always some trial court level, appellate level, and highest court. We talked a little bit about the job of the appellate or reviewing court. They focus on questions of law. They defer to the trial court that was in the position to determine what the facts were. The highest state court, they were appeals that involve state issues. They have the final say on questions of state law. And the only way you're going to move on to federal court is if the case also involves some federal issue. The pleadings, the plaintiff complains. They serve that complaint with a summons on the defendant. The defendant has several choices. They could answer, they could admit or deny the allegations in the complaint, move to dismiss, perhaps alleging that the court doesn't have jurisdiction over them, or even answer and file a counterclaim, claiming there's something that the plaintiff did wrong. After that, there's pretrial motions, a motion for judgment on the pleadings. One party says they accept the facts or statements in the pleadings and ask the court to rule on that, or perhaps there's limited issues that need to be decided and there could be summary judgment. The next step is discovery. Discovery is determining what evidence the other side has. Depositions are oral testimony under oath. Interrogatories are written questions under oath that are given to the other side. There are lots of other types of discovery, requesting information, even electronic information from the other party, email. And then there's a pretrial conference. There's a couple purposes usually for pretrial. It's obviously to set it for trial, make sure all the deadlines are met, or establish any future deadlines before trial, but also to try to get the parties to settle the case. The next step is voir dire, or jury selection, and then the trial. Typically there's plaintiff and defendant having opening arguments at the start, but certainly the plaintiff goes first because they have the burden of proof. The defendant could wait until after the plaintiff's presented their case. Plaintiff presents witnesses, the defendant cross-examines. At the end, for example, at the end of the plaintiff's proofs, the defendant can move for a directed verdict, say the plaintiff has failed to establish their case. Otherwise, they finish the trial, closing arguments, and then the judge or jury makes an award in one favor or the other. Post-trial motions. Motion J&OV basically is asking the court to set aside the jury's verdict. A motion for a new trial. Perhaps there's evidence that couldn't have been discovered before that's now discovered, and then there's the appeal process. The appeal, basically the parties file a brief with the appellate court asking for a decision on an issue that would require a reversal of the trial court's verdict. The court doesn't review new evidence. It only considers the briefs, perhaps oral arguments by the attorneys, and just looks at the record and evidence introduced at trial. And then there can be some effort to enforce a judgment. I mean, you could get in a judgment against a party and then they don't pay up, then you have to go to court to get them to pay the judgment. Some of these activities take place online. Most courts have electronic filing. Some have other proceedings, preliminary hearings, online. There hasn't been a real successful project to put the whole court system online. The three types of mediation, alternative dispute resolution, could also take place online. We'll talk about that in a little more detail in a minute. You could do negotiations, mediation, arbitration. So looking in, so far we've been talking about litigation, which basically the parties suing each other and going through court. Negotiation could certainly take place during a trial, but also could take place outside or before a trial. Negotiation is not using a third party, but resolving the dispute between plaintiff and defendant. Perhaps sue attorneys, but the parties negotiate and settle it themselves. Mediation is typically non-binding and involves a neutral third party, so the plaintiff defendant present it to a mediator. That mediator renders a recommendation or decision, and if it's non-binding, then they could actually go on to trial. Arbitration is typically binding. Like it says here, an example is an employment contract is often binding because it is agreed upon. So credit cards, employment contracts, whatever it is, it says if a dispute arises between the parties, then the employee would, as an example, would take it to an arbitrator versus taking it to court. So if the employee were to take it straight to court, then the employer could move to dismiss the case, saying that the employment contract required arbitration instead of litigation. So those are the three major. There were other forms of alternative dispute mentioned in the chapter, but those are the three big ones. And that's the end of Chapter 3.